Now, Sri Singh.
Mr. Deputy Chairman, sir, as I rise to speak on this important historical legislation or this constitutional amendment which is in front of us, a poor economist like me of the dismal science cannot be both overawed and feel protected. Overawed, as I turn to my right, there was this distinguished Arun Jaitley ji, there is Ravi Shankar ji, and of course the fabled Mr. Ram Jethmalani, who has, of course, a reputation which is so formidable. Next to me is, sitting next to me is Satish Mishra ji, another formidable. And of course, Parasaran ji, who sits behind, has been a guru of so many of us who have read judgments. And of course, there is Minister Kapil Sibal ji piloting this bill. There is Mr. Rajiv Shukla, whose new dimensions of how much this is embedded in his gene particles, something which was exposed by one of his relations, both from his marriage side and from his paternal side. But of course, while, sir, one is overawed with this formidable kind of a thing, one is also well protected. That whether one has the requisite money or not, we feel quite protected in whatever we are going to say. So I think that on the broad issue of whether or not this important legislation should be taken in conjunction with the other bill, which we believe should go to the standing committee, I think that the minister would like to have an assurance from you that the important point which has been raised by the leader of the opposition, that there is no hiatus, and that Parliament is not legislating a hiatus. Parliament is legislating for continuity and not hiatus. We'd like to be assured on that, and of course the other important point, that an important far-reaching legislation of this kind does not look to be an act of hurry, but looks to be well-considered legislation in consultation with all other stakeholders. So broadly speaking, I have 3 points to make for the consideration of the minister. First, who can doubt that this particular commission should be based on the principles of equality, transparency, openness, impartiality, but also efficacy and efficiency. These should be the overarching considerations of any commission of this kind. So we must address ourselves this one important question before we come to the next question. The one important question we must ask ourselves: how does India's legislative module, a legislative architecture, a judicial architecture, compare itself with the best international practice? Now, looking at the existing literature, one very important literature, Minister, I came across was a case of 1883 when a superior council of the judiciary was created by the French Parliament as acting as a court of cassation, in which they purged the existing judges which existed and laid down a different procedure for appointment of judges. Such was the extent of complaint. This is a very famous quoted case. Now, nobody here is intending to purge any judge, I think, but we intend to learn from the best international practice. Now, what are the best international practice? The best international practice broadly falls into 4 categories. Category 1, nomination by the executive. Category 2, election. Category 3, co-option by the judiciary. And category 4, appointment by committee consisting of judges and academics. Broadly speaking, this is how countries have divided themselves. For instance, Italy, Spain, and Sweden believe in the separate appointments commission. Israel and USA believe that the appointments must be confirmed by the legislature. Canada, France, Germany, South Africa, and United Kingdom have a recommendation or a screening by a separate appointments committee. Indeed, Minister, we fall in a very unique category of some hybrid species called the collegium, which is incestuous in character, which nominates, which screens, which selects, and which monitors. No other country in the world falls in this particularly absurd hybrid category when it performs functions which are incestuous and which have inherent conflict of interest. So I think that one of the things I'm sure Minister would like to do is to try and see how, when we are undertaking this far-reaching important reforms, in how the new architecture which you want to create will conform with the best existing international practice. So I want to not go into the need for judicial reforms, not merely because there are 30 million cases, 74% of which are pending for more than 5 years, but I want to raise the more basic issue. And the basic issue is this, that wherever I have gone, Minister, we have taken great credit for the fact that India believes in the rule of law, that India has a fiercely independent judiciary, which is not going to be influenced by anybody. Investors, you please believe in us because of the independence of the judiciary. And yet, how is it, sir, then, that in a report like the Ease of Doing Business, 2013, India ranks at the bottom on sanctity of contract, on issues of insolvency, on inordinate delay, and something which the investors believe that notwithstanding all your claims, you have serious deficiencies. What are some of these important deficiencies? While the economy, Minister, has evolved in the last 60 years, some of which was really very well brought out by the leader of the opposition when he spoke, our politics has become more complex. Our federal structure has become more complex. Our economy has not only evolved, it has become globally much more interdependent. The judiciary, sir, remains locked up and frozen in a time warp. They have not evolved. So one of the things which I strongly recommend, Minister, is that you must increase the domain knowledge and the domain speciality of judges who will represent us, who will really be in the High Court and who will be at the Supreme Court. Let me give you a few examples. International investors have told me that not that your judges are suffering from economic illiteracy, nobody accuses them of that, but they certainly accuse the fact that when it comes to transfer pricing policy, when it comes to interpretation of intellectual property rights, when it comes to fixation of tariffs, when it comes to allocation of scarce natural resources, the practices and judgments do not really suggest that there is a degree of appreciation of what the best international law on those subjects are. Therefore, as we become increasingly much more interdependent, we need to blend a degree of always avoiding moral hazard, but a degree of pragmatism when it comes to such important decisions like, for instance, allocation of natural resources, on which, Minister, there is so much debate. When it comes to issues which has really made India an interdependent part of the global economy. Until we are able to do that, sir, investors in this country, investors all over the world will not be able to be assured that India genuinely believes in a rule of law which is comforting, which is predictable, and which is certain. So I think that as we travel all along, of course, the Prime Minister outlined the many considerations which have led to the tardy slowness of the Indian economy. The leader of the opposition dramatically brought out some other cases where I think some of the decisions have really contributed to this kind of a sluggishness of the Indian economy. Indeed, while the fierceness and independence of our judiciary is something which makes us proud, we need to make sure that this independent structure is not an impediment, but is an accelerator in India's economic progress. We need to look at from the prism of a different kind of whether the practices, processes, judgments, and pronouncements conform to what the rest of the world express and hope for what is going to be and what we pride ourselves to be new economic engine of power on the globe becomes. This, Minister, must be our overarching consideration. This must be the vision which must guide the important features and architecture of a new judicial reform process of which today's bill is one very, very important consideration. Finally, Mr. Deputy Chairman, I agree with the Leader of the Opposition that when the judgment is pronounced by any judge, particularly a judge by the Honorable Supreme Court, there is only one judge who is above that, and that's the Lord Almighty, who is above us, who will look to this much beyond our life. But we know one thing, that the road to heaven is always paved with good intentions. The road to heaven is paved with good intentions, but let us not make that pavement so tortuous, so meandering, that we lose our path to go to the heaven. Thank you very much, sir.
Thank you.